Hi everybody, welcome to another episode of Foreclosure Help 777, where we talk about every way we can to fight foreclosure. You can join my Facebook page, Sue Your Lender, Fight Foreclosure and Mortgage Fraud, where we can talk to each other about ways we can actually win. So today we're going to talk about a very important subject, and that has to do with discovery. And what is discovery? Well, we're going to talk about the federal rules of civil procedure, and my friend Sabrina Kohler, she actually she's going to file discovery on the other side soon, but she wants to get her discovery ready to give to the other side. But they have to respond to discovery requests when you send them. Let's look at what that looks like. Okay, so here's the cover letter to the discovery request. At the top, she has her name and address. And then you want to insert the date when we're ready to mail it. And then you need the address for the attorney for the bank. Right now, that's the address of the other side, but as soon as we get an answer to her complaint, they'll tell us who's handling it, what attorney that is, and their address. And we would send this to that attorney. So we have the docket number next. And then basically the cover letter says, please answer and return the discovery request as soon as possible per the federal rules of civil procedure. I have attached the following: interrogatories, admissions, requests for production of documents, and things. Thank you. And basically you just, you sign it, date it, and then that's the cover letter to the discovery request. Now here's the actual first page of the first set of interrogatory questions. And it says, per rules of civil procedure. I like to put that in there so that they understand that they have to follow the federal rules of civil procedure and answer these questions. And as far as interrogatories go, you can look up the Rule 33 about interrogatories to parties, and it tells you. Good website is Cornell Law School. They tell you how many days that they have to respond and how many questions that you can submit to them. So the number of questions that you submit to them is no more than 25 written interrogatories, including all discrete subparts, etc. So it tells you how long they have. It's basically they have 30 days to respond. It says time to respond. The responding party must serve its answers and any objections within 30 days after being served with the interrogatories. And so if they need more time, they can also let you know they need more time, or they can object to them. Okay, let's look at the interrogatory questions that Sabrina is using in her case. That'll give you an idea of what kind of questions you'll need to think about when you're making your own. So she has 25 questions. The first one is basically identify all of the loan numbers and loan applications for all of the loans that the plaintiff has had. Give the date for each loan change and reason why. Give the name of all of the brokers, loan officers, representatives that have personal knowledge in regard to the origination, applications, and all loan documents, emails, and telephone calls. Personal knowledge is the key word here. A attorney for the bank does not have personal knowledge, and so you might need to object when they try to say something that you know that they can't possibly know. Number 3, explain why you contacted the plaintiff about the promissory note was lost, damaged, or destroyed, and a new one had to be signed. Provide the person's name and contact information that came by the plaintiff's house to fix this problem. Everybody's situation is different, so you might want to think about certain things that may have happened that you want them to answer better. Number 4 is give the date that the plaintiff defaulted on the loan number, and the number of days past due. Number 5, explain what you do when the plaintiff sent in extra mortgage payments and the account shows paid ahead status. Number 6, if any payments were returned to the plaintiff, please state the date of the payment, the amount, and the reason why it was returned. Number 7, the plaintiff. Okay, number 7 is plaintiff was charged attorney's fees. Give the dates, the amounts, and the reason for each time an attorney fee was charged. Plaintiff was charged fees for appraisal. Give amounts for all appraisals done and charged to the plaintiff and the name of the company that did the appraisal. Number 9, plaintiff was charged a $20 inspection fee. Provide the dates, amounts, and reason why an inspection was necessary. Number 10, please explain why the publication fee charged to the plaintiff is for. Number 11, please explain what the fees charged to the plaintiff for mail is for. Number 12, please explain the fees charged to the plaintiff for FC title and title fees. Give amounts, dates, and reasons for each charge. Number 13, name the person, organization, address, telephone number of who funded the plaintiff's loan. Number 14, on August 16, 2021, plaintiff was charged late fees when the account was paid ahead. Explain why this happened. Number 15, plaintiff's hazard insurance premium payment changed. Give the name of each insurance policy, the policy number, the yearly premium, and the dates and amounts for each payment. Number 16, explain if you ever received any benefit, fee, payment, or kickback for the FHA program regarding the CARES Act. Number 17, please state if the subject loan was ever assigned to a different entity from the origination date to present. Please give contact name, address, telephone numbers, account numbers, email addresses of each party that has been assigned the loan. Number 18, please state if plaintiff ever contacted you in regard to any fraudulent documents, forgery, or unauthorized signatures. Give the dates and response by you to the plaintiff. Number 19, provide an explanation of why the promissory note was missing or damaged and what was done as a result. Number 20, give the name of the party, address, telephone number, email address of the owner of the plaintiff's promissory note. Number 21, give the name of the party, address, telephone number, and email address of the owner of the plaintiff's deed of trust. 22, give the name of each loan servicer and subservicer, the loan number, address, and the date the servicer changed or loan number changed. Number 23, what actions did you take to investigate the plaintiff's claims that the loan was fraudulent? Number 24, explain why MERS Corp. Was listed as the assignee and assigner on plaintiff's property on the assignment of deed of trust. Give the dates the MERS MIN number became active and inactive. Number 25, explain the deed of trust assignments that were filed in the recorder of deeds regarding the plaintiff's loan. Give dates, actual parties' names, not MERS, assigner, assignee for each assignment. If the promissory note is not endorsed, the same as the deed of trust, explain why. Okay, and those are the 25 questions that she's going to submit. Now, we're going to talk about the next part of discovery, which are admissions. Admissions are kind of like you're asking them to admit or deny what's going on with the loan. And we come up with 25 questions where they can either admit or deny. And they have to either answer admit or deny and send it back. Okay, so the first one, admit or deny that the plaintiff's loan documents have 4 signatures. Admit or deny. that Noah Ortiz is the loan officer that can testify in court and has personal knowledge regarding the life of the loan. Number 3, that the plaintiff was charged attorney's fees. Number 4, that the plaintiff never wanted a no cash out refinance. Number 5, that Brokers Solutions does not own the promissory note or deed of trust. Number 6, that New American Funding does not own the promissory note or deed of trust. Number 7, that MidFirst Bank does not own the promissory note or deed of trust. And then number 8, that the plaintiff's note and deed of trust was sold or securitized into a trust. Number 9, that you returned any payments to the plaintiff. Number 10, that the plaintiff was never advised or given the right of rescission. Number 11, that the first loan was paid off by the second loan. Number 12, that MidFirst Bank is not licensed to do business in the state of Missouri. Number 13, that the signatures for Arthur Genuine are not wet ink signatures but computer-generated script fonts that look like a signature. Number 14, that the 3 separate loan applications had incorrect information on them. Number 15, that the loan application showed married when not married. 16, that the loan application was submitted without the plaintiff's knowledge. Number 17, that the FHA HUD gave CARES Act incentives to people that had government loans. Number 18, that the plaintiff's promissory note was bifurcated or split from the deed of trust. 19, that MERS or Moore's Corps is listed as the assignee/assigner on the deed of trust, but not the promissory note. Number 20, that the MERS MIN number associated with the subject loan is inactive. 21, that the plaintiff's credit report was damaged when the debt was disputed. Number 22, that someone submitted a claim to HUD to pay off the subject loan. Number 23, that Brokers Solutions, doing business as New American Funding, has unclean hands by a lawsuit involving the False Claims Act and the United States of America. And then there's the actual docket number there. Admit or deny. Number 24, that the plaintiff's loan is just one of many loans that the defendants have procured under the false and fraudulent pretenses. Number 25, that the plaintiff was forced into default by charging excessive fees, returning payments, and incorrectly crediting payments. Okay, so that's all of those. Now we'll go into the last part of discovery, which is request for production of documents and things. Again, I put the civil rules of the Federal Rules of Civil Procedure, Rule 34 talks about this, how they have to give that to you when you're asking. And so these are the things that we've asked them to provide. And again, everybody's different. You might want to ask for different things, but this gives you an idea of what she's asking for. Number 1, produce the original wet ink signature note. Number 2, produce a complete payment history of both loans. Number 3, produce a hard copy of all loan applications. Number 4, produce a hard copy of all FHA-related communication regarding the subject loans. Number 5, produce all emails, electronic mail from all representatives that have anything to do with either loans. Number 6, produce a copy of all letters and all written correspondence between the plaintiff and defendants. Number 7, produce copies of all appraisals to which the plaintiff was charged a fee. Number 8, produce copies of all attorney's fees to which the plaintiff was charged a fee. Number 9, produce copies of all title or FC title related fees to which the plaintiff was charged. Number 10, produce copies of all publication notices, notice of publication to which the plaintiff was charged, include all publications. Produce all servicing loan records from start to present for both loans. Number 12, produce all post-closing loan documents. Number 13, produce copies of all letters that were mailed to any entity regarding the subject property. Number 14, produce all MERS documentation, MERS MIN numbers showing active status, inactive status for when the purported loan was transferred. Number 15, produce receipts for every transaction made in regard to selling the loan servicing to a different entity. Number 16, produce both HUD-1 settlement statements for both loans. Number 17, produce documentation for any and all hazard insurance and forced place insurance. Number 18, provide letters that show the loan was transferred to a different party. 19, provide letters that show the loan number had changed. Number 20, provide copies of all letters that were sent to the plaintiff for both loans. Number 21, provide copies of any consent orders that the SEC, Securities and Exchange Commission, have made to either Brokers Solutions, New American Funding, or Midland Mortgage. Provide hard copies of all letters that were sent to any outside sources regarding the subject loan, the Attorney General, or the Consumer Finance Protection Bureau. Number 23, produce information on who the investor of this loan is and how they acquired the loan. Number 24, provide a copy of the subservicing agreement if the servicing rights to the subject loan have changed. Number 25, provide copies of all pre-loan and post-closing loan documents, including the notes. Okay, so that concludes the discovery request that she's going to be sending to the other side. It doesn't get filed with the court. It goes to the other side. Remember, you don't file it with the court. You send it certified mail to the attorney that's handling the case for the bank. They have 30 days to respond, or 60 days. If you haven't had a settlement conference scheduled, you don't want to file a motion to compel discovery until they've had enough time to respond to your request, just so you know. All right, well, I hope this has been helpful to y'all. And if you have any questions regarding discovery, leave them in the comment section below, and I will answer your question. And I hope everyone has a wonderful day.